Hello everyone, welcome back to our channel. In today's video, we are diving deep into the employee stock option scheme draft because the scheme is a fundamental document for implementation of ESOP. This is a powerful tool. ESOP is a powerful tool that helps the companies retain talent and align employee interest with a long-term business growth. So whether you are a founder, HR professional, or compliance advisor, or a student, understanding how to structure and implement an employee stock option, because this can be a game changer for your organization. So we'll walk through the key components of the draft policy, eligibility and criteria, vesting schedules, exit mechanisms, and governance under the scheme. It will take a long time because we have to discuss in detail. So if you are looking into launch a ESOP in your company, just want to understand how it works. So this video is for you. Let's get started. This is ESOP scheme 2025. So this scheme shall be called DAS ESOP scheme 2025. So your company name you can give. Hereinafter referred as a scheme. So this scheme, first it has to be approved by the board of directors and shareholders of the company by way of special resolution. Here we will write the dates, board resolution date and members approval date. The scheme shall be effective from the date of approval of this scheme by the shareholders. So that is the effective date. We'll fill the date here. Wherever applicable, the scheme shall be in accordance with the regulations prescribed by the Security Exchange Board of India or any other regulatory authority as applicable to the company and shall not contravene any other law for the time being in force. That is, material is giving effect to such scheme. Why we are going to SEBI? Because the scheme which we are drafting is for the company proposed IPO or for the listed company. For private companies, they can follow. Unlisted companies, they can follow Companies Act 2013. Unlisted companies. And for listed companies, mandatorily has to follow SEBI, share-based employee benefits, state equity regulations. Even proposed IPO companies have regulations. Now we will talk about the term of this scheme. So the scheme shall continue to effect unless terminated by the board of directors or until all options which are available, because the pool will be, so the options all are available to be granted under the scheme are fully exercised and fully utilized for the benefit of the employees. Then they can go for termination. That is their choice. Any such termination of the scheme shall not affect the options already available, already granted, and such options shall remain in full force and effects as if the scheme had not been terminated unless mutually agreed otherwise between the grantee or nominee or legal aids and the company. So it means that any such termination shall not affect the options already available with the employees. So the purpose and the objects of the scheme. So the purpose is to motivate the employees and contribute to the growth and profitability of the company, to build a reliable and strong ecosystem of employees, to achieve sustained growth and creation of shareholder value by aligning the interests of the employees with the long-term interest of the company. To create a value-driven system for employees that is inclusive in nature and allow the employees to participate in the success of the company. This is the purpose. So it means to create a sense of ownership and participation among the employees to share the value they create for the company in the years to come. This will motivate. And share-based employee benefits provided under the scheme, the benefits grant the employee stock options to the employees. We'll talk about the definitions we have to clearly draft the definition. See, applicable law, we are talking about Companies Act 2013 and SEBI Act, SEBI regulations, and all applicable laws, employee benefit, all applicable employee benefit laws in force, and associate company definition as defined under Companies Act 2013, and board of directors means board of directors of the company only, and body corporate as defined under the Companies Act 2013, and committee means nomination remuneration committee, which will be appointed as a compensation committee, and company means your company name. Corporate actions means that includes rights issue, bonus issue, any change in the capital structure, IPO, merger amalgamations, any reorganization of corporate or corporate structuring. These are all called as a corporate action. Directors means directors appointed to the board of directors of the company. Here the most important the definition employee. Employee means because employee designated by the company who is exclusively working in India or outside India under the payrolls of the company. And director also comes under employees, but excluding director, whether full-time director or not, excluding promoter, member of promoter group, and independent directors. The ESOPs cannot be given to promoters, member of promoter group, and independent directors. And even this employee definition, which we have discussed, which is even employee of the group companies, including subsidiary company, associate company in India or outside India, a holding company of the company. So ESOPs can be given to not only to the company, the group company, including subsidiary company, associate company in India or outside India, or a holding company of the company. So, but does not include employee who is a promoter and promoter belonging to the promoter group. These are excluded from the definition of employee, and does not include a director who is either himself or through his relatives or through any body corporate directly or indirectly holds more than 10% of the outstanding equity shares of the company. So, if director holds either directly or indirectly more than 10% of the outstanding equity shares, so he will also exclude from the employee definition. And such other person has may be specified by the share-based employee benefit and equity regulations. This is the definition of employee, because now you are clear who comes under the definition of employee and who is not the employee. And eligibility criteria. So this eligibility criteria may be determined from time to time by the nomination remuneration committee for grant or vesting options in compliance with the share-based employee benefit and equity regulations. Exercise. Exercise means making an application by an employee to the company for issue of shares against vested options in pursuance of the scheme covered under the scheme. So once the options are vested, then the employee will make an application to the nomination remuneration committee. That is called exercise one, committee for exercise the options. So here 3 stages are there. First stage is granting options. Second stage, vesting of options. Third stage, exercising. Once exercised, this will be converted into shares. So there will be a period for exercise, that is called exercise period. Company will provide after vesting. Then the time will be given, either 2 months or 2 years or 1 year. This is purely the discretion of the nomination remuneration committee. NRC will decide the time period after vesting within which an employee can exercise these options. Exercise price, this is a predetermined price. This will be decided by the NRC at the time of grant. In the grant letter only, we have to clearly mention exercise price also. Fair value, the definition of fair value. Fair value means fair value of an option calculated in accordance with the accounting policies specified in Regulation 15 of share-based employee benefit and sweat equity regulations under the applicable law. Grant means the process by which the company issue options under the scheme. Grant date means the date which the committee, the date on which the committee approves the grant of options to employees. The date is called as grant date. Grant letter, because company will issue the letter substantially in the form provided in the scheme, intimating an eligible employee of the options granted to such eligible employee for acquiring a specific number of shares at the exercise price and as per the vesting period described there. This grant letter, this is an intimation to the employee. Yes, certain number of options are you are eligible. Once it is vested, then you can exercise. This will be converted into shares. Full details will be given in the grant letter. This is an intimation to the employee. That employee will call as a grantee. Holding company, as per the definition under the Companies Act 2013, and independent director. Yes, this definition in the independent directors will follow as SEBI LODR regulations and as per the definition given under section 2, subsection 47 of the Companies Act 2013. Lock-in period. The definition of lock-in period is for which the shareholder shall be prohibited to transfer or trade in the shares issued pursuant to through this scheme. So lock-in period is not mandatory. So it is purely the discretion of the company. Market price. So how we take market price? The definition. The latest available closing price on the recognized stock exchange on which the shares of the company are listed on the date immediately prior to the relevant date. So what is the relevant date here? So the date when the employee make an application for exercise the vested options. Options, the employee stock options means the option given to the employee. This is not an obligation. This is a right to purchase or subscribe at a future date, which is a predetermined price. So this grantee, who is grantee? Employee is the grantee who receives the grant letter. Here we'll talk about the permanent disability also. Permanent disability means this will be decided by the board of directors based on the certificate issued by the medical expert. Promoter shall have the same meaning in regulation 2, SEBI share-based employee benefit and sweat equity regulations. Even promoter group also as defined in the regulation 2 of share-based employee benefit and sweat equity regulations. And what is recognized stock exchange? It means which has been granted recognition under section 4 of SCERA, Securities Contract Regulation Act. And definition of relative shall have the same meaning as defined in regulation 2 of share-based employee benefit and sweat equity regulations. And what is the relevant date? Here, there are two relevant dates. In case of grant, the date of the meeting of the committee on which the grant is made, that is one relevant date for grant. Another relevant date in case of exercise. After vesting, the employee will make an application for exercise. So the date on which the notice of exercise is given by the employee to the company, that is called relevant date for exercise. So one should be familiar with all these definitions. Then only can understand the basic document, fundamental document scheme, ESOP scheme. These definitions are very, very important to understand. What is the scheme? Scheme shall mean dash ESOP scheme. In the dash, we can give any name or you can write company name. Dash ESOP scheme 2025 and shall include any alterations, amendments, additions, deletions, modifications, or variations from time to time. SEBI share-based employee benefit and sweaty equity regulations. SEBI LODR regulations means Securities Exchange Board of India, listing obligation and disclosure requirement regulation 2015 shall include all alterations, amendments, additions, deletions, and modifications and variation. Shares means equity shares of the company. Subsidiaries shall have the same meaning as defined in Regulation 2 of SEBI LODR and will also follow Section 2, Subsection 87 of Companies Act 2013. And we also talk about vested option, unvested option. So unvested options means an option which is not vested. Vested means which are vested in pursuance of the scheme. Mandatory vesting period is 1 year. Vesting means process by which the grantee becomes entitled to receive the benefit of the grant made to him under the scheme. So the vesting means once vested the day onwards, he is getting a right to exercise. That is vesting date. That is a mandatory 1 year period will be given. Thereby he becomes exercisable. The grants will becomes exercisable. The vesting period will be decided by the NRC. Full-time director, yes, shall have the same meaning as defined under the Companies Act 2013. And we will also discuss about the interpretations. So singular includes plural and vice versa. And the word person, wherever we are discussing, that includes individual or a firm or a body corporate or unincorporated body or authority. Any word, expression, importing the masculine, feminine or neutral gender shall be taken include all three genders. Any word which is not defined under this scheme shall be interpreted in line with the applicable law and SEBI regulations. Articles here, headings are only for information, shall not affect the construction of these documents. A reference to an article is prospectively a reference to an article of this document. Reference to any act, rules, or statute or notification shall include any statutory modification, substitution, or reenactment thereof. This is what the interpretation, how you will take in the scheme. So even though it is a lengthy document, but once again I am reiterating, stay till the end because these are the basic technical terms. One should be familiar. Then only you will understand the entire scheme and implementation and administration of the scheme. So subject to applicable laws, that is Companies Act and SEBI regulations and our employee benefit legislations. Subject to applicable laws, the framework laid by the Board of Directors, the scheme shall be administered by the committee, here nomination remuneration committee, and it may delegate some or all of the powers as it may deem fit for proper implementation and administration. Even committee also further can delegate the powers for implementation. The committee is authorized to interpret the scheme because members are approving and giving the power to establish, amend, and resign any rules or regulations relating to the scheme and to make any other determinations that it deems necessary or desirable for the administration and implementation of the scheme in accordance with the applicable provision of the law. Any decision of the committee Committee means nomination admission committee. In the interpretation and administration of the scheme and described herein shall lie within its sole and absolute discretion and shall be the final, conclusive, and binding on all the parties concerned, including but not limited to grantee or employee and their nominees and legal aids. And the committee, here we are talking about compensation committee, that is MRC, shall subject to applicable laws have powers. Committee shall have powers to implement an administration. The shareholders are approving and giving the powers. The committee can delegate its duties and powers in whole or in parts as may decide from time to time, as may be required. And committee shall have power to decide upon the stopping of options which were lapsed. There are certain occasions because when the grantee is not responding, is not accepting within 30 days of the grant letter issue, then that will lapse. Or there are chances when termination, resignations, misconduct by the employees. We'll talk all about all these. I'll explain. So, committee has the power to decide stopping on options which are lapsed, forfeited, or surrendered under the provisions of the scheme for B grantee. So, to increase or decrease the pool of options to be granted under the scheme, committee can take a decision. And to increase or decrease the pool, or to identify the eligible employees to participate in the scheme and eligible for grant options. So the eligibility of the employee will be decided by the committee. And to finalize the eligibility criteria for grant options and to determine the number of options to be granted for each grantee and in aggregate subject to the pool of options of the scheme. So all options granted are subject to pool of options. To decide upon granting of options to new joiners. So this grant can be issued to the existing employees and even to new joiners. This will be decided by the nomination remuneration committee. And this committee has the power to determine the grant date because committee will approve the grants. The date is called grant date. And has the power to grant options to one or more eligible employees to calculate the exercise price after giving discount on market price. So generally it has to be attractive price, the discounted price. To extend the period of acceptance of grant. So within 30 days after issuing the grant letter, employee has to accept. Otherwise it will lapse. In certain cases, case-to-case basis, the committee can extend the period if it is a valuable reason. And committee to decide the vesting period because the mandatory vesting period is 1 year. And the vesting period can be extended 1 year, 2 year, 3 year, 4 year, 5 year. This can be decided by the NRC, subject to mandatory 1 year. To determine the vesting schedule for each grantee, it is not like a common to all the grantees. And to finalize the eligibility criteria for vesting options, it may be seniority or it may be linked with any targets, performance. To determine the employee for vesting options, to decide upon the mode and manner of exercise options, and to decide upon treatment of vested and unvested options. Suppose unvested options are there, so NRC can take a decision to re-grant options in case of cessation of employment as specified in the scheme. And to decide upon the treatment of vested unvested options in the event of corporate options. Suppose there is a bonus issue, there is a rights issue. So then what about the unvested or vested options? So that will be decided. That will be decided by the NRC, and taking into consideration the following points, the number and price of options will be adjusted in a manner such that the total value to the grantee of the options remains the same after the corporate action. Because of the corporate action, the already available grants shall not be affected. So the vesting period and the life of options shall be left unaltered, because once it is given, try to see that as far as possible it shall not be unaltered. To cancel, the committee has the power to cancel all or any granted options in accordance with the scheme. To accelerate the vesting and exercise of options on a case-to-case basis, subject to completion of minimum 1 year from the date of grant. That is a minimum vesting period. And to decide upon the treatment of vested and unvested options in case of dispute between the grantee and the company. So the committee will take a decision to finalize letters and other documents, if any, required to be issued under the scheme. So most of the powers are lying with the committee, NRC, during the implementation to reprice the options which are not exercised. Suppose the price is not attractive, employees are not exercising, so NRC will take a decision to establish, amend, suspend, waive such rules and regulations as it shall be deemed appropriate for proper administration of the scheme. Then committee will take a decision. And to terminate the scheme, then committee will take a decision. Committee has the power to appoint such agents shall deem necessary for proper administration of the scheme. And committee has the power to determine or impose other conditions to the grant options under the scheme as it may deem appropriate. And NRC can frame suitable policies and procedures to ensure that there is no violation of securities laws, because subject to securities laws, including SEBI regulations, SEBI PIT regulations, SEBI prohibition of fraudulent and unfair trade practices relating to the securities market regulations 2003, and as amended from time to time. See, to determine the procedure for funding the exercise of the company's options. Suppose the employee doesn't have money, so how to fund by the company? And even for allotment, so NRC will take a decision, allotment to even the trust route, if it is a trust route. So money is required for purchasing, for allotting options, allotting shares to the trust. So the funding, NRC will take a decision whether company will pay or company will arrange any loan by giving a guarantee. So this will be decided by the NRC. So to decide upon vesting or unvesting the options in case of the permanent incapacity. So these are all the powers given to the NRC. Scheme has to be drafted in such a way that there shall not be any dispute. There shall not be any room for creating any doubt. The powers and functions of the committee can be specified, varied, altered, or modified from time to time by the board of directors, subject to rules and regulations as may be enforced. So that the board of directors may further provide that the committee shall exercise certain powers only after consultation with the board of directors, and in such case, the said powers shall be exercised accordingly. So board of directors will guide the committee. The members of the committee shall abstain from participating in and deciding on any matter relating to grant of any options to himself because of the related party. So in the event of inconsistency between the provisions of the scheme and the provisions of the employment offer letter to the or employment agreement of the eligible employee. If there is a dispute, then the provisions of the scheme shall prevail. Now we will discuss about the pool of the scheme, that is quantum of the scheme. So the total number of options that may be granted pursuant to this scheme shall not exceed. So we'll give the number, which shall be convertible into equal number of equity shares of face value of dash, face value for your company, whether it is a 10 rupee or 100 rupees, unless otherwise determined by the committee. So we have to clearly finalize the number of pools. And if any options under the scheme, suppose lapse or cancelled or forfeited or terminated or surrendered or settled under any provisions of the scheme, such options shall be available for further grant under the scheme unless otherwise determined by the company. Hope you are clear. So further, the maximum number of options that can be granted and the shares arise upon the exercise of these options shall be stand adjusted in case of corporate actions. So even there is a rights issue or any of corporate actions, bonus issue, so accordingly, committee will adjust. Further, the maximum number of options that can be granted and the shares arise upon exercise of these options shall stand adjusted in case of the corporate actions. The company reserves the right to increase or decrease such a number of options as it deems fit in accordance with the applicable. Next, the important topic we will discuss eligibility criteria. The eligibility criteria. It is identified a class of persons eligible under the scheme. This will be decided by the nomination remuneration committee. Only employees are eligible for being granted options under the scheme pursuant to applicable provisions of the law, and the committee shall identify the class of persons eligible under the scheme. The eligibility criteria of the employees shall be determined by the NRC at its sole discretion in accordance with the applicable law. We will discuss about eligibility in detail, because I again reiterate, this is a fundamental document. You should be clear with the scheme. So the committee may, on the basis of all or any of the following criteria, decide on the employees. That is called grantees. Grantees are nothing but employees only who are eligible for the grant. First grant, next vesting, and next exercise. Either it may be level or role of the employee in the company, or performance of the employee, performance during the financial year on the basis of the parameters and the stands decided by the board of directors, job profile, team and responsibility level of the employee, and the present and potential contribution of the employee to the success of the company. High market value, difficulty in replacing the employee, high risk of losing the employee to competition, value addition by the new entrant, if any. So in case you can give even for new employees also. Any other criteria are decided by the committee in consultation with the board of directors from time to time. So the employees satisfying the eligibility criteria shall be termed as an eligible employee. So new joiners can also participate in the scheme and be granted options in the scheme based upon the discretion of the committee. So nothing in this scheme or any option granted pursuant to the scheme shall confer on any employee any right to continue as a employment of the company. So once the grant letter is given to the employee, this is not the right to continuation of the employment or giving any dividend or giving any right to participate. These are all only options only. So the appraisal process for determining the eligibility of the employee will be based on the designation, period of service, performance linked parameters such as work performance and such other criteria as may be determined by the committee in sole discretion from time to time. Anyway, board will guide to the committee. Now, grant options. I will explain about grant options. The committee shall grant options to one or more eligible employees in accordance with the terms and conditions of the scheme for the time being in force and subject to employee and employment terms or is continuity in the employment and other parameters are set out by the company. The maximum number of stock options to be granted to eligible employees shall be decided by the committee, whether it is 100 or 1,000. So number of stock options. One stock option is one share. So the maximum options that may be granted per employee and in aggregate shall vary depending upon the designation and appraisal assessment process. The committee reserves the right to decide the number of options to be granted and maximum number of options that can be granted to each employee within this ceiling. So subject to availability of options in the pool under the scheme, the number of options that can be granted to the employees as may be identified the board of directors or nomination remuneration committee under this scheme during any 1 year or may exceed 1% of the issued capital, excluding outstanding warrant of the company at the time of grant. If at all, any 1% above of the paid up capital are issuing as ESOPs to employees, and special resolution is required. So the maximum quantum be benefits that will be provided to every eligible employee under the scheme will be difference between the market value of the company share on the stock exchanges on the date exercise of options on the exercise price paid by the company. So I'll explain you the benefit. What is the benefit of the employee? See, the benefit is the price difference. Price difference will see what is the market price on the date when he is exercising and what is the exercise price. Suppose exercise price is a face value 10 rupees. The market rate is 100 rupees. Then 90 rupees is the benefit to the employee. So the maximum quantum benefit that will be provided to every eligible employee under the scheme will be the difference of the market value of the company and the date of exercise of the options and the exercise price. So the grant of options shall be communicated to the eligible employee in writing through grant letter, specifying full details, vesting date, number of options granted, the exercise price, and vesting schedule, and other terms and conditions thereof. So all the details will be given in the grant letter. No amount shall be payable by an employee at the time of grant option. Employee need not pay any amount at the time of grant option. Only at the time of the exercise, you will pay the amount for exercising the options. Upon grant options, an eligible employee shall become the grantee under the scheme. Grantee is the employee who receives the grant letter. So unless agreed otherwise between the company and the employee, subject to the corporate actions taken by the company, if any, the grant of one option to an employee under the scheme shall be equal to one share in the company upon payment of the exercise of the price. So 1,000 options are giving means 1,000 shares upon exercise of the options. So the options granted to the eligible employee shall not be transferable to any other person. Because these are all options, not shares. Until exercised, it cannot be transferred. No person other than the employee to whom the option is granted shall be entitled to the benefit arising out of the such option. You cannot transfer your benefit to other employee. As a condition to the receipt of the benefits here and there, each grantee, that is each employee who received this, may be required to exercise related agreements in the form of satisfactory to the committee, which may include but are not limited to non-competition agreement, confidentiality agreement, non-solicitation, non-interference, adherence to the code of conduct, non-disclosure agreement with the company, as well as tax indemnification agreements in accordance with the grant options. So at the time of grant, so these are the documents. This is not mandatory, but discretion of the committee. So this has to be executed by the grantee, that is the employee. So what is the method of acceptance? I will explain. Any grantee who wishes to accept the grantee. So company will issue the grant letter. So if the employee is willing to accept, so must deliver a signed copy of the grant letter, acceptance letter. Along with the grant letter, acceptance letter will be given. So within which 30 days time will be given, within which for on or before that last day, he has to sign and submit that acceptance letter. Any grantee who fails to return that signed copy and acceptance letter, then the options will be elapsed. They will be treated as a rejection. So the grantee is not required to pay any amount at the time of receipt of the grant letter. So subject to terms contained in acceptance in accordance with this article of a grant made to grantee shall conclude the contract between the company and grantee, because company has given grant letter and employee has accepted and also returned the acceptance form. So the contract is completed between the company and the grantee. Grantee has to abide by all the terms and conditions. So now we'll discuss about vesting of options. I already told minimum 1 year is the mandatory period. After receiving the options, they has to wait for minimum 1 year. That is the law. And further that is the discretion of the NRC. So now in practice in the market, it may stretching up to 5 years also. Every year like 25%, 20%, it depends. Discretionary power given to the NRC. So the vesting options will be on yearly basis. I'll give you an example. Suppose 1,000 options company is giving to an employee. So how it is 4 years, you can say like 25% every year. First year 25%. 250 options he can exercise, which will be converted into shares. Another 250 in next year. Similarly. So the vesting schedule and the terms and conditions thereof will be communicated to the respective grantee through grant letter, subject to applicable law. The committee shall have the power to determine the right of an employee to exercise all options vested in him in one time or various points of times within the exercise period. Because the exercise period will be given after vesting also. Because availability of funds also need to check with the employee. So he may be given either 2 months or 1 year or maximum 2 years. It depends the company to company. NRC will give the time. NRC will take a decision. So during that time, employee has to exercise, otherwise it will be lapse. So you are clear that the minimum vesting period is 1 year as specified by law. This shall not apply in case of any death of the employee. So at the time of acceptance, employee has to submit his nomination to either to his relatives, either wife, father, mother. So if something goes wrong during the employment, there is a death of the employee, then there that minimum 1 year vesting period will not apply. So with the effect from the date of his death or her death, the legal heirs or nominees of the deceased employee can exercise. So the actual vesting may further be linked with the eligibility criteria as determined by the committee as amended, as mentioned in the grant letter. So it may be linked with the performance we have discussed. So the committee shall have the power to modify or accelerate the vesting schedule on case-to-case basis subject to minimum 1 year. The options which get lapsed due to eligibility criteria, including a reason of lapse of exercise period, suppose employee has not exercised, then it will be lapsed, or due to resignation of employees, or otherwise would be available for being re-granted. So those options again will be re-granted. The decision will be taken by the nomination committee. If at all any fraction entitlement to which the grantee would become entitled to what are vesting options, then the option to be actually vested be rounded up to nearest to lower integer, because we'll talk about the percentages. So if any fractions comes, this is the solution. Rounding off to nearest to lower integer. Now we will talk about exercise of options. Now we'll discuss exercise of options. So this is the third stage, because the first stage is the granting stage, second stage is the vesting stage, and third stage is the exercise. So after vesting, the options shall be exercised. There are two routes, cash route and cashless route. So cash route is, in this route, employee will pay the amount as decided by that is called NRC, that is exercise price, and company will allot shares. So that payment face value and this will be treated as a perquisite, so TDS also applicable. Then employee will pay and the company will allot the shares. Another route, cashless route, where employee doesn't have money. He can request the committee, you sell it and take the expenditure like TDS and income tax involved, and the remaining amount will be credited to the employee. That is a cash route and cashless route. Anyway, exercise period will be given either 2 months, 1 year, or 2 years. During that period, employee has to take a decision. Upon allotment of shares, grantee shall become the member of the company. Now he will become the member of the company. Notwithstanding anything contained elsewhere in the scheme, company may not allot shares in the event of grantee being found to be involved in fraud or misfeasance or gross negligence, breach of trust like events. And in such an events, the rights under the options, whether vested or not vested, shall lapse forthwith and without any claim or reports to the company. So if at all any this misfeasance and gross negligence breach is there, so these options will be lapsed. So if the vesting or exercise of options preempted by any law or regulations in force, suppose the court made any attachment, the company is not liable for that. The committee shall have a power to cancel all or any of the actions granted under the scheme, if so required under any law for the time being in force, or the order of the any jurisdictional court in the event of any such cancellation. The company shall not be liable because the court directions. Now we will discuss about the exercise price. Subject to SEBI regulations, the committee shall determine the exercise price. This is the discretionary power given to the NRC and subject to applicable SEBI regulations. Either it may be face value and it shall be an attractive price. as may deem appropriate in conformity with the applicable accounting policies, if any, provided that the exercise price shall not be less than the face value of the shares and not more than the market value. If it is more than market value, then it is not attractive. So the aggregate exercise price payable and tax amount arising at the time of exercise of option shall be payable at the time of exercise by a check or demand draft drawn in the name of the company. So these expenditure has to be paid by the employee. That is a grantee. The liability of payment of taxes is the liability falls on the employee grantee. The company shall have the right and cause its relevant subsidiary. See, the company shall have a right and cause its relevant subsidiary or holding company to deduct from the options grantee. Suppose if any dues are there in relation with the ESOP, so then company has a right to deduct that amount either from the amount from the employee, even from the salary, whether it is related to that company holding or subsidiary company. So upon the exercise of the options by the grantee, the company shall have no obligation to deliver the shares until the tax deduction obligation of the company or the subsidiary or the holding company, as the case may be, have been satisfied with the employee, because this is a responsibility of the employee. So till that time, the shares will not be transferred. So company has the right. So the company may reprice the options. Suppose if the price is not attractive, then market price is less than the exercise price, then that time NRC will take a decision. Cessation of employment. This is an important class. Suppose, subject to the employment terms of the grantee, the following terms shall be applicable. See, in the event of cessation of the employment due to death, in the event of death, we already discussed, no? Then all the options granted, all the options under the scheme shall fall on the legalized or nominees. So their vesting period is not required. The options will be exercised by the legalized within the exercise period. The period will be given like 3 months. Within the exercise period, if they don't respond, then that will be lapse. So all the terms and conditions of this scheme shall apply to such options, provided that in order to exercise the options of the deceased grantee, the legalized or nominees has to submit the following documents. Document, in case of nominee is not appointed, then copy of succession certificate, probate of will or letter of administration, or NOC from other legal aids, and photocopy of the death certificate duly attested by the proper authority, specimen signature of the persons in whose name the shares are to be transmitted, copy of PAN card and the application self-attested, copy of address proof self-attested. These are the documents needs to be submitted by the nominee. And in case of nominee is appointed, suppose the nominee is appointed, then photocopy of the death certificate duly attested by the proper authority and specimen signature of the persons in whose name shares are to be transmitted, and copy of PAN card and copy of address proof self-attested. Then these documents needs to be submitted by the nominees to the nomination examination committee. In the event of cessation of employment due to permanent incapacity, suppose if there is any due to any accident, then the same. These now in that permanent incapacity, then is all vested. See, there is no need of vesting period. Then all the options granted to him or her under the scheme on the date of permanent incapacity shall vest in him on that day only. So the vested options would be exercisable within a period of 3 months from the date of permanent disability, failing which the entire exercise option shall lapse. So during the exercise period which is given by the NRC, decided by the NRC, so during that period, he has to exercise. Even in the case of permanent incapacity, no need to wait for as per the vesting schedule. In the event of cessation due to resignation or termination, now this is important. See, all unvested options. Suppose the vested options are not even vested. and the date of cessation shall expire and stand terminated with effect from the date of from that day unless otherwise determined by the committee whose decision will be the final binding. Subject to terms and conditions formulated by the committee in accordance with the ESOP regulations. All vested options, suppose where options are already vested, then shall be exercised by the grantee by the last day of employment in the organization or before expiry of the exercise period, whichever is earlier. So the vested options not so exercised shall lapse irrevocably, and the right thereunder shall be extinguished. So if vested options are there, he has to exercise. If vested options are unvested options are there, that shall be lapsed. So in the event of cessation of employment due to retirement or superannuation. So in the event of cessation of employment due to retirement or superannuation, so here in this case the options granted on the employee will continue to vest in accordance with the respective vesting schedule even after the retirement or superannuation in accordance with the company's policies and applicable. Now we will discuss in the event of cessation of employment due to termination due to misconduct or unethical or compliance violations. In that case, because of the misconduct, all options granted, whether vested or not, whether vested or not, shall stand terminated with immediate effect, unless otherwise determined by the committee, whose determination shall be final and binding. And in the event of that the grantee is transferred or deputed to associate company or subsidiary company, no problem, that period will be considered and it will be continued. In the event of grantee going on long leave from the office more than 3 months, then NRC will take a decision. In the event where the dispute arises between the grantee and the company, the vesting and exercise options, then that will be put on hold till the date of settlement to the transaction of the committee. Once that dispute finalized, then shares will be released. So the committee may modify the terms of grant and vesting exercise options in case of any cessation of employment mentioned in foregoing paras, as we have discussed now. So what about locking requirement? Locking means you cannot transfer. So this is a prohibition to transfer. This is locking is not mandatory. This is only optional. So that will be decided by NRC. The terms and conditions right of the grantees. See, grantee, once the options are given, grantee will not have any right of participating in the meetings or any right of getting a dividend. He will not getting any votes. He will not get any vote, but he has a right that, like the other shareholders, the notice letters and annual accounts will be supplied to the grantee. He will not have voting right, but after issuing the grant letter from that day onwards, and the meeting notices and annual accounts will be supplied to the grantee. So nothing here is intended to or shall give the grantee any right to status of any kind of shareholder of the company in respect of the shares covered on the grant, unless grantee exercise the options. Once exercised, he will become the shareholder. So the grantee shall not be entitled to any compensation or damage or any loss which he may suffer by reason of being unable to exercise. So if he is not exercising, he cannot ask any compensation to the company. So the grantee shall be abide by the company's code of conduct for prevention of insider trading and code of practices and procedures of fair disclosures of unpublished price sensitive information adopted by the company under SEBI with regulations. So the option grantee not have the right to receive any dividend and vote till the exercise. What about the notices and correspondence? So whatever the address is given in the acceptance letter, that will be treated as the communication address to the grantee. If at all any change in the address or email ID, phone number, grantee can intimate the NRC. Similarly, whatever is address there in the company grant letter, then that is the communication address where grantee can communicate. And the nomination of beneficiary, each grantee under the scheme may nominate from time to time in case of his death. So corporate actions, any corporate actions like bonus issue, rights issue, or any merger amalgamations, accordingly, the options will be adjusted. That will not affect the already available options to the grantees. In the event of severance of employment of grantee as part of reconstitution or amalgamation, suppose any vesting period is there, that period already continued in transferor company, so that will be considered in transferring company, not an issue. In the event of liquidation, this is important, or dissolution of the company, so any vested options not exercised, so that will be lapsed. And disclosure and accounting policies. So the company shall comply with the requirement of EDAs. Such other accounting treatment and policies as may be prescribed from time to time. The company shall use fair value method or such valuation method as may be prescribed from time to time in accordance with the all applicable laws, and computing the compensation cost from the options granted, including any guidance note on accounting for employee share-based payments issued in the regard from time to time. Because accounting treatment as per the accounting policies and guidance note. Compensation cost will be booked in the books of account of the company as per the accounting standards. Taxability on the grantee at the time of exercise, this benefit is treated as a perquisite and applied as per the Income Tax Act. And after that, once he sells shares, after exercising, options will be converted into shares. Once the shares are sold by the employee, there is a grantee, then that tax will be as per the holding period. Then that is depends on the capital gain that will be taxed. So it is the two stages tax at the time of exercise, treated as a perquisite, and at the time of selling of shares, then that is a capital gain tax. Then this has to be it has to be done by the employee only, not by the company. So there is a double point taxation. Surrender of options. If suppose any employee want to surrender his options, company will not pay any compensation. In the event of any dispute arising between the employee and the company, yes, there will be an arbitration clause, and place will be decided, arbitration place. And as per the arbitration, the clause will be given in the scheme itself. Governing laws, yes, as per the Indian governing laws, Companies Act and SEBI regulations and all applicable laws, and regulatory approvals, then NRC will take care of all the regulatory approvals, and modification of scheme subject to approval of the shareholders. The committee may at any time revoke and alter or amend as per the requirement, but subject to shareholder approval, and that will not affect the rights of the guarantee already available. Options are available in the market. And confidentiality, yes, confidentiality agreement will be entered between the company and the grantee. This is what in depth about the fundamental document. This is the scheme. Once scheme is clearly understood, then it's a very easy to implement, and even for advisors, very easy to advise. Even for professional student, it's very, very important to understand the scheme. This is the crucial document. I have explained in detail. I think hope you are clear. Request to subscribe RR Corporates. We have other channel, RR Legal Talks. We have two channels, YouTube channels. Thank you.